Journalism is not a crime. We are witnessing one of the most serious frontal attacks on freedom of the press since the Pentagon Papers and indeed in the history of the United States. I'm so grateful to be with you on this panel. You really have been treated to such excellent analysis so far with Kevin and Marjorie. I'm very grateful to the Assange Defense Committee here in the United States, as well as to Ileana. And I want to use this moment because it's the first public opportunity I have since seeing Stella Assange speak outside the High Court of Justice during these hearings. How brave, how courageous. Her remarks will go down as one of the strongest defenses of freedom of the press and freedom of speech in an international context. This case is that important, and I am delighted that you as viewers are getting a chance to appreciate a deep analysis. I want to say that none of us can fully cover the important issues that are at stake in this case. Please look for the work of Kevin and Marjorie in their respective websites, books, and articles. I've been privileged to gather my articles at truthdig.org, which has a special page devoted to the Assange case. This case is nothing less than an example of a government that is going to the ends of the earth outside of its own jurisdiction to prosecute a journalist and publisher for exposing, in this case, U.S. war crimes using a 100-year-old statute against a person for conduct committed outside of the United States in an unprecedented prosecution, which is unlike anything that has ever been sought in the history of the United States. That is how distinctive we must consider this unprecedented prosecution, and why the case is important not only for the law of the United States, but for international law. And there's no better example of why that is so important than the name Evan Gershkovich, the Wall Street Journal reporter that presently resides in prison in Moscow, as far as we know. Can you imagine if Russia had applied to the UK for extradition of Evan Gershkovich to bring him back to Moscow to stand trial on what charges? Espionage. Espionage, the very same charges the US is using against Julian Assange. It would be unthinkable for the UK to extradite this individual, and it is equally as unthinkable to consider extraditing Julian Assange. The struggle for freedom of the press and freedom of speech throughout history has confronted authoritarian governments who have put a label on free speech in order to criminalize it and to punish outsiders, dissenters, and critics of those governments. We can go back in history to punishing heresy and blasphemy, punishing sedition, the very notion of libeling the government. In the United States, we had a dark period of punishing communists for their expressed beliefs. And now we come down to punishing espionage. It is a mere label that governments use to punish free speech and free expression. Now, the hearings that were held in the High Court of Justice simply perpetuate the degree to which the United States government is seeking to punish Julian Assange for having exposed U.S. wrongdoing. We believed this throughout this prosecution, but the testimony, and in some cases it felt like testimony coming from the British lawyers who represented the United States, most prominently Claire Dobbin. Her remarks in oral argument took on the force of testimony, as if she had some kind of personal knowledge or information to shore up her opinions. She also used a tactic that we should become more familiar with, and that is putting a criminal label on conduct which is otherwise entirely legal. In this case, she put criminal labels on what journalists, investigative journalists in particular, do every day. One of her statements was to accuse Julian Assange of his complicity going beyond receipt. It's the encouragement and incitement to steal the material that puts Julian at the end of the spectrum of gravity, her language. So what she's doing, and the record now, the record before the administrative judge, barrister, is ample. The testimony of leading journalists, of leading First Amendment authorities. Investigative journalists encourage their sources to come forward. They solicit information from sources. They obtain that information, and then they analyze it and they publish it. You could say they conspire in a colloquial sense, but not in any criminal sense. And what is so dangerous about the most recent arguments is the attempt to put scary labels like incitement and stealing of documents on the conduct that investigative journalists engage in every day. And that's why this poses such a threat, because if this nomenclature is adopted by the High Court, if extradition is granted and Julian Assange is forced to stand trial in Alexandria, Virginia, there is no limit to the journalists that can be prosecuted under this very same theory, whether it's journalists being prosecuted under the Espionage Act of 1917 or journalists in any other country around the world, as we have seen. A Pulitzer Prize-winning journalist, Barton Gellman, who led the Washington Post's reporting on the Edward Snowden documents, has said, and it's as if it were a confession in advance of his own conduct, that Assange is charged with asking for information, with receiving information, and with publishing information. And I don't mind saying that these are exactly the things that I do. Gellman has said that if asking questions and protecting a source are cast as circumstantial evidence of guilt, we'll be crossing a dangerous line. Now, Prosecutor Dobbin would not allow treating Chelsea Manning as a whistleblower because she responded to a solicitation and gave bulk data sets. She says it was unrealistic to submit that she gave any thought to specific disclosures when that she wanted to raise. This is Dobbin mischaracterizing the motivation of Chelsea Manning. I'll say here that I'm concerned about the procedure we are examining. I'm concerned whether these two British judges will pay unnecessary reliance and defer to these British advocates for the United States, because any serious examination of the record, any serious examination of the evidence would lead to the denial of extradition. I'm in the midst of giving you one example because Chelsea Manning's motives are a matter of public record. We don't need Miss Dobbin to speculate over Chelsea Manning's motives. Chelsea Manning said, quote, "I hope that the public would be alarmed as me about the conduct of the aerial weapons team crew members." And she went on to give other specifics. Those are the facts in the record, not the speculation of a lawyer speaking for the United States government. Now, I want to touch on a point that my colleagues referred to in passing, which needs emphasis. To be extradited, Julian Assange and the charges against him must satisfy the dual criminality requirement. What he is charged with must also be a crime in the UK. And Judge Johnson questioned Dobbin and said, if in this country a journalist had information of very serious wrongdoing by an intelligence agency and incited an employee to provide that information, and it was provided and published carefully, would a prosecution be compatible with Article 10, which is the European Convention on Human Rights Protection for Freedom of Speech? And Dobbin couldn't answer the question. She waffled. She said, I'm not sure that it would give way to a straightforward answer. And then she went back to her legal argument that there is no public interest defense, which I think Marjorie has clearly demolished. In terms of Dobbin, the court went on to ask, would Assange be afforded First Amendment protection if sent to be tried in the United States? And that judge fortunately knew the record well enough to say that U.S. Attorney Kronberg at the extradition hearings said he wouldn't, which would conflict with section of the UK Extradition Act. And again, Dobbin waffled and dissembled. We are not in any position to assess whether this is established as a matter of case law. And she referred to a possible argument. She is luring this court to grant extradition without confirming that he would have his full First Amendment defense in the United States. And it is a serious risk because U.S. authorities, including Mike Pompeo and lawyers at the Department of Justice, have denied that he has a First Amendment defense. They want to use the Espionage Act in an extraterritorial way to reach an Australian citizen now sitting in England, but they don't want to promise to afford him the same protections of the U.S. Constitution and the First Amendment. I want to touch on two final points so we can get to our discussion and questions, and that is the computer hacking charge under the Computer Fraud and Abuse Act. My colleagues have already touched on this, but I want to alert listeners that I have some concern that the judges in the UK will let the tail wag the dog, that they may latch on to this one count of computer fraud and abuse and grant extradition, whatever position they take on the rest of the charges. This would be a huge mistake based on the record, which Kevin and others have discussed, because that charge is entirely false and undermined by the facts in the case and by the testimony at her court-martial of Chelsea Manning and of other information. I am worried that they are going to treat Assange not as a journalist and therefore will use this as a hook to extradite him. Finally, I want to mention the European Court of Human Rights. It's important that our audience understand that if the British courts now in the High Court deny the appeal and they order Julian Assange's extradition, the activism that all of us have been trained to exercise will be on high alert. The European Court of Human Rights has ample grounds to consider Julian Assange's case. Marjorie has identified the various provisions. Article 10 regarding freedom of speech, Article 5 regarding arbitrary detention, Article 7, which needs to get far more attention, which is you have a right not to be prosecuted for acts which did not constitute an offense at the time of the conduct. It is only now in this unprecedented prosecution that the routine activities of journalists is being treated as criminal, retroactive to the time of Julian Assange's conduct. So that article deserves European Court of Human Rights attention, as well as a fair trial and Articles 2 and 3 regarding the right to be free from torture or inhumane and degrading treatment. Now, immediately, if there's an order of extradition, Julian's lawyers are prepared to go to the European Court of Human Rights. They will proceed first under Article 39, which provides for provisional remedies, including a stay of the underlying order of extradition in this case. They will need to prove, and I believe they can prove, exceptional circumstances and the imminent risk of irreparable harm. My greatest fear today is that the UK and the United States will cooperate in putting Julian Assange on an airplane and whisking him to Alexandria, Virginia, before the European Court of Human Rights can hear, determine, and issue a stay of the extradition order. This has happened in the past. There are awful examples of attempts to whisk people out of the UK for this purpose. On the other hand, previous stays of extradition to the United States have been granted on the basis of the health of the person charged. That's been done in 1997, 2001, 2004, 2009, and 2013. I think it would be an example of international outrage if the UK and the United States conspire in whisking Julian Assange away from UK jurisdiction and European jurisdiction to take him to the United States. But all of us are going to have to be alert to that possibility, and the kinds of protests we saw outside of the High Court will have to be launched, whether it's midnight or 3 a.m. or a high noon, and we'll have to be protesting here in the United States and demand that the right to appeal to the European Court of Human Rights is protected and exercised. That's what's at stake in this case, and that's why it's so important for each one of you watching this webinar to understand the gravity of these issues and to take action in each of your homes and communities. Thank you very much.